Now we're live.
Now we're live.
Now we're live. So, not legal advice and little JR. We're just, I say it little JR because there's a big JR. He was unable to attend tonight, but we hope to have him in the future. So I have to distinguish between the two. And again, I've indicated I don't know if little JR is bigger than big JR. But
well, our names are right there. The names show. So when Big JR comes on, he can put Big JR in all caps.
All right. And what do you get? Just I have to throw this out, by the way, just to get it out of the way.
Sure.
What do you get when you mix alcohol and literature? Tequila Mockingbird. All right.
How apropos for tonight,
yeah,
right?
Kind of. So we decided we were, I don't know if last night or the night before, we saw there was a decision called Jareasky versus the SEC. And Brian and I were talking about it because when we looked at it, it sounded like it had similar facts set up to GTII. Yes. And we were wondering what the applicability is. And I'm going to briefly kind of give you the background on the facts. So Jareasky or Jareasky, however you pronounce his name, and I apologize for mispronouncing it, and others set up a hedge fund. They were not wholly honest with their investors. They raised $24 million. I think they misrepresented the auditors, some other things, the value of the assets so they could collect a bigger fee. And the SEC went after them. So they went after them and ordered a cease and desist order for them to stop doing what they were doing, ordered, I think, a $300,000 penalty, and ordered them to give back something on the order of $645,000 back to whomever they had stolen it from. So that went up eventually went up on appeal to the Fifth Circuit. The three kind of basic issues were that they were constitutional issues. One, that they were entitled to a trial by jury under the Seventh Amendment. Two, that there was an improper delegation of authority from Congress to the SEC because there was no list of what the SEC should do and how they should do it. They basically were given absolute discretion to handle fraudulent issues of fraud without any kind of guidance. And last was that the adjudicatory system was improper because it should have been an appointment by an executive, and it wasn't. So that case has gone up on appeal, is now going to go up to the U.S. Supreme Court. That term starts in October, and we would expect a decision sometime before summer, but we don't know when because it depends on when it fits in the schedule. So hearing that, because of the cease and desist order, and because it involved the SEC, it caught our imagination, and we spoke about it. We talked about, we thought maybe that Alpine's counsel was going to go in and seek a stay of the order of the appellate court because we thought they were going to cite this U.S. Supreme Court case for the basis. But it turns out that based on the ruling today, that the appellate court issued an injunction stopping the Finra from continuing with their expedited enforcement proceeding, which was to enforce the cease and desist order, which was from April of 2022. And this court who issued the order today, so we don't really know, we're just we looked at it fresh and we've talked about it for like 10 minutes beforehand, but we're kind of just shooting like we usually do. We're kind of just shooting from the hip and just kind of throwing it out there.
Right.
But the court seemed to focus on the fact that the adjudicators at Finra should have been appointed judges, and the fact that it was not violated the Constitution appointment clause. There's other arguments that were made in, I think, the complaint filed by GTII, but that's what not filed by Alpine, excuse me, but that's what the appellate court seemed to focus on. And they also were pretty direct, because we were talking about this. They were pretty direct by saying that based on what they see as of now, they think as to this particular issue, Alpine's going to win the appeal. So we talked about that. And by the way, kick me or step in anytime you want me to shut up.
Well, I think let's point out that it was a panel of 3 judges. 2 judges found to rule in favor of the injunction. 1 ruled against it, but we did not see where they wrote a dissenting opinion or see what their thoughts on the matter were. So it was a 2-3 or 2-1 decision.
Right. So how it would go from this point in time, let's assume that, and remind me, Brian, when I go this, obviously FINRA could then go to federal court to enforce its rights. But let's say they don't. Remind me about what I just said. If it goes forward, there's a briefing schedule that's already come out. So like so there's an appeal that's pending, even though the court has indicated the way they preliminarily see it. There's going to be a bunch of briefs filed, and they may have a different conclusion after the briefing's filed. But the way the briefing schedule is the initial brief is August 14th, then a reply brief September 13th, and then a further reply brief October 4th. That's the briefing schedule. That could change also. If there's oral argument, probably within 90 days of the last brief, but doesn't necessarily have to be oral argument. So, and what were you supposed to remind me about?
Going into federal court to enforce their right.
All right. So that's if they don't. That's if they just kind of let the appeal run its course.
Right.
But part of the reason why the injunction was granted by the court was because there weren't properly appointed judges adjudicating the matter. So I think you could deal with that subject matter and that particular ground in the Alpine case if you went into federal court. We have Article 3 judges, so you've now complied with whatever issue there is as to that. Present your case as to the cease and desist. Might be slightly complicated because you'd have to be basically presenting the whole thing at once, because the finding in the April 2022 matter may be at issue. So you may not be able to use that finding, but you probably could present to the judge, here are all the facts, you make the finding. And and that way I think you're in compliance with what the appellate court had a problem with. And I think that would go much faster than the briefing on the appeal. My belief.
So let's take a step back up and make sure everyone understands what you're talking about. So the appellate court, the 3-judge panel appellate court basically ruled in favor of the injunction, stopping the enforcement in front of the SEC enforcement officer on constitutional grounds. Those constitutional grounds are a variety of things, but the big one was basically unconstitutional delegation to this person that has authority to rule one way or another, and such that if they rule one way and Alpine gets booted out, it's the death sentence for them. Okay. What you're saying, though, is, okay, to alleviate that constitutional issue, FINRA could just say, to hell with it. We're just going to file in a federal district court and go through the process all over again.
Well, it wouldn't be all over again. I mean, I proposed this remedy already. They could go into federal court. They could seek the appointment of a receiver to take over the business of Alpine. There would be a hearing, an evidentiary hearing, like a mini trial. Probably be very quick. But the grounds would be that the public's at risk, and you could show there's been 35,000 violations of a prior order or conduct that would be inappropriate.
Let's play devil's advocate here. So if I'm Alpine, what's my argument going to be? I'm going to argue, whoa, Your Honor. They're now trying to circumvent basically unconstitutionally delegated authority in order, for them to appoint these, again, random people that have this decision-making authority that's basically executive authority, right? That's the issue. They're now circumventing the appellate court. They're circumventing the district court by filing an action against us in federal district court, which you are an Article 3 judge. There's no issue there. But our position now is, Your Honor, they don't have any authority to act. They've got nothing. They're an unconstitutional body as a whole, which, by the way, Your Honor, we have a claim filed in D.C. District Court right now that the appeal, the injunction basically threw back. So this all should be kicked out pending that decision, because the judges already said they think we're going to at least win on one issue. That would be my argument if I were Alpine's attorney, if FINRA decided to do that.
Well, they might make that argument after I filed my action, and then we might end up in front of that same appellate court. But right. I would say the difference is in that Jareasky, whatever that J, we'll call it the J case, the J case.
Fifth Circuit case.
Yeah, the case that's going up to the Supreme Court. That's different because the grounds asserted were broader. In our case, just based upon the granting of the injunction, the court seemed to relate to the issue of the judge. The FINRA judge were comparable to the SEC judges that were not appropriate. So as long as we satisfy that judicial requirement, when I file an action before a federal judge, I think I'm in compliance, because that's what the court limited me in their order. They don't address they may down the road. I mean, I'd be surprised in the further briefing, if those other two arguments about the delegation and the right to a jury trial under the Seventh Amendment, if they're not addressed. But right now, in the order that we saw today, it wasn't. So I don't think it's appropriate for the court to stop my proceeding based upon our compliance with the judicial issue.
Your Honor, the Supreme Court just took this petition under certiorari to put an end to the question of whether or not all this stuff is constitutional. You know, at the very least, Your Honor, I don't think this enforcement action should be going forward in federal court until the Supreme Court rules on the Fifth Circuit decision.
Well,
because it could have broader implications for FINRA and their ability to act.
This is not an enforcement action. This is an action to protect the public good and public interest. Has nothing to do with penalizing. We're not going to we're not penalizing Alpine. We're not seeking to expel them. We're not speaking to impose any kind of penalty or fine. We are only seeking to protect the public from a prior finding that the public is at risk from misconduct undertaken by Alpine. And we have evidence to back that up.
You're in federal court to circumvent the enforcement decisions that were unconstitutionally determined back in April 2022, and now this latest one that's been halted.
No, I just want to protect I just want to protect Junk Savvy and Busy Brands and Big JR.
You can spin it any way you want, but that's why you're here.
If that's the result, I can't help it. But the reason why we're here is to protect the public. All right.
What's the old saying? It's form over substance. It's form over substance.
So, but let's move on, because we talked about that. So we don't know what's going to happen. That's the bottom line is. But it certainly appears that the Supreme Court is interested in limiting the power and authority of federal agencies. That appears to be what's going on. So along those lines, if they can restrict the authority and power of FINRA by making them have Article 3 judges or something else, that's quite a impact on their authority, because they lose kind of control over the handling of matters. And I don't know how it works financially. Maybe a different financial outcome.
Well, it calls into question, as we talked prior to this, it calls into question, I think it's starting to poke holes in FINRA's constitutionality. If they're now questioning the delegation of authority, they're basically saying that Congress didn't enact, what was the shit? Congress unconstitutionally delegated legislative power to the SEC by failing to provide it with an intelligible principle by which to exercise that delegated power.
Right.
So they're calling into question FINRA's authority to act. And as you and I talked, so now you're taking it from, okay, they've circumvented the right to a jury trial because they have these unappointed, again, we don't know what to call them now, but these unappointed people that can rule one way or another based on enforcement actions. And now they're basically saying, well, Congress didn't delegate things correctly. So now you've got two major tenets of FINRA, their enforcement actions and their authority to act. So if you take those two things, what's the next thing that then follows, Richard? It's what we talked about, right? I'm posing the question to you because it's a big issue for you.
Yeah, we're talking about immunity. So what happens? What happens if there's an improper grant? Because the way it's going, or at least the way it starts with the case that's going up to the Supreme Court, an improper grant to SEC, and then Alpine is an improper grant to FINRA. And if there's an improper grant to FINRA, then they're really private, and they really have no authority. Then perhaps they have no immunity too, and perhaps then if they have a beef, their beef is with the federal government, not with us, where they may be exposed to liability. Because that seems that would be consistent with limiting their powers and authority, because one of their powers is to escape liability. That's one of the chief powers.
Sure.
And I noticed that in one of the, I think it was the case going to the U.S. Supreme Court, when they were talking about the issue of the delegation, what they focused on in part was that there was an absolute discretion. And as we were talking about with regard to, FINRA, and even more so as to arbitrations managed by FINRA, which we also talked about, there's absolute discretion because there's basically no right of appeal, and there's no way of challenging that. And in large part, after you get an award from FINRA, you can't go back to the arbiters to get it enforced.
Right.
So on one hand, in the case like that's Jareasky or whatever that stupid case's name, one of the issues is like a right to a jury trial and a fair trial. That's kind of one of the issues, besides the lack of delegation and the lack of the proper appointment. But if you're raising issues and the courts are sympathetic to those claims, and there's an improper delegation because FINRA is administrating those mandatory arbitrations.
Right.
So doesn't that impact, or does it potentially impact the right to require mandatory arbitration? And should FINRA be administering it? And when we entered into the agreement that allowed your broker to conduct arbitration, if you would have known that FINRA didn't have the authority to do it, would you have agreed to it?
Right.
And those are things, we don't know. But obviously, those are things that I think are going to be argued in the future, because we're arguing it. We're talking about it. We're not
nobody.
Yeah, we're not specialists in the area. As a matter of fact, we had a joke. We were talking about it like 2 nights ago, and we said, listen, if we're talking about it, we know Counsel for Alpine and FIT, they're all talking about it. So, yeah. So, but it's interesting ultimately because if FINRA's ability and to require arbitration, and if more importantly, if the brokers lose the ability to mandate arbitration and they're required to litigate everything in federal court or state court before a jury, the numbers will be significantly higher. Mm-hmm. Their legal costs will be significantly higher, and they won't be able to bury a lot of things they're able to try and bury in arbitrations. And nice flannel, by the way.
Yeah, it's 60 degrees down here, guys. I'm freezing my ass off.
And part of what we talked about is there's a report apparently that's going to come out from the House Committee on Appropriations that examined registered investment advisors who required their clients to do arbitration and found out that ultimately it sucked. That was their conclusion. Although it hasn't been come out, so I haven't seen it, but I got a story on it today.
Right.
And they also said that one of the problems is, and it kind of goes back to what I said about one of the problems with arbitration, that there's a significant percentage, and they were citing a study that said 30%. Could be large, could be larger, but over 30% of the awards were not collected. And the problem, unlike like a court, and this is another point that can be made, but unlike a court, if I get a judgment against someone, I can go to a court, and even though the court's not going to go out and visit the guy with his buddy Guido to knock on the door, but there's certain mechanisms I can use in court to try to enforce the judgment. Right. In arbitration before FINRA, once that award is issued, that arbiter is done. No more involvement. You can't collect it. Sorry, Charlie. What's the irony is to do and explain how this makes any sense. The irony is if you have a judgment that's not collectible in an arbitration award, to get it enforced, you'd have to file a new action in court.
In federal court.
To enforce the judgment, where they told you not to go to court in the first place, but to enforce the judgment,
Yeah. Yeah. The whole notion, I mean, you and I have talked about this ad nauseum. The whole notion of mandatory arbitration is all in your terms of service agreement. And to your point, if you're starting to see this chipping away by way of legal cases of FINRA's authority, these two decisions right now, the Fifth Circuit appellate court decision, as well as the appellate court decision in Alpine, is chipping away. And I'm going to pat myself on the back for this, because I've said this all along. It's very similar to the approach that Dr. King and Thurgood Marshall took in the civil rights movement. They picked away at little chunks, until by the time they got to the Supreme Court, it did not make sense for Brown versus Board of Education and the doctrine of separate but equal. Now, I think it's if you think about it, it's funny that, MMTLP happened, and now we're starting to see these broader legal arguments be made against FINRA and their constitutional authority. I'm not suggesting it's because MMTLP happened, but the timing is amazing with all of this.
I think it's because of you.
Is it? Yeah. All right. Damn it. It's because of me. I get it.
I mean, everybody should jump on the board. We should get little JR Nobel Prize, right? Nobel Prize for little JR.
Oh, yeah. How would that be? We'd like to welcome, Brian Garman, armchair lawyer in his basement wearing a flannel. He's now won the Nobel Peace Prize.
Oh, perfect.
I think this should make me one of those pro lawyers, 50 over 50. You know what I mean? Whatever that is, those lame,
I have no idea what you're talking about.
Things that you guys get.
Yeah, I know. Oh, you're one of those guys making those false promises late at night?
It's 1-800-GO-JR.
Yes. Yeah, I wanted to make one thing clear before anybody jumped off a cliff. So let's go back to GTII. So I don't think substantively it changes anything. So if in fact Alpine are scumbags, they're still scumbags, and the day will come, they will pay the price.
Right.
But in terms of expectations about when they would get kicked out, I would say those probably have been pushed back a little bit. We don't know specifically, but realistically, it's probably pushed back a little bit in time.
Well, if push comes to shove, the SEC can act. They have authority to act. It's just that authority has been delegated down to FINRA. So
I don't think. I think with those decisions, I think they would go to court. I happen to think if I were their attorney, I would say, we might still get stuck, but let's at least get a judge to issue the order and not have our people do it, and give them full evidentiary, time to put on a case. Because I thought maybe they'd give a super expedited briefing schedule, but I didn't think it was super expedited. And I've thought, by the way, and I don't know if I'm going to do it or not. So that I have an action pending in federal court on appeal against FINRA. Right. And I saw these cases and I thought, wow, maybe it made me think. I think I could weave these into my appeal. And then I thought, there's an issue about arbitration, because again, I think if the delegation to SEC to FINRA is improper, then maybe those mandatory arbitration provisions have a problem also. So what I've thought about today, and I'll see what goes on tomorrow, but I've thought about bringing a separate action in federal court against Fidelity, asking the court to make a ruling as to whether there's a mandatory obligation to participate in arbitration with fidelity based upon these issues.
Yeah. I mean, when you read both these cases, there's no question that the judges in these cases are questioning the constitutional authority of FINRA.
Oh, absolutely. And the SEC. And the SEC.
And the
Yeah,
SEC.
and the
It's
SEC.
huge.
Yeah.
So at this point, I think anything is game. I mean, I really do. If you make a clear and concise argument and point to these two cases and say, look, the Supreme Court is reviewing this right now, and yeah, it's only one leg of the three-legged stool, but it's a pretty damn big leg.
Yeah, and it might be the case, pun intended, that you might file an action. Because I was thinking about like the timing; it would be interesting. So let's say, I have an appeal. I'm just kind of talking out loud because I don't know how it's going to go. But let's say my appeal, the briefs. Let's say my Ninth Circuit appeal. Let's say it's like going to be decided in early 2024, and this Jareasky case is on the docket in the U.S. Supreme Court. I think it's very possible that my court would wait to see the ruling to make sure the U.S. Supreme Court didn't like make some ruling that completely required them to act in a specific way. And I think that's a possibility, and the other thing is the same thing would apply if I filed an action with fidelity. So I know I could see the action already. I file the action, and I'm playing with the theory. I have like a general theory like bouncing in my head, like rocks. Rocks are bouncing off my head. It hurts, kind of, by the way, but I don't know like specifically. But I would, if I filed an action in federal court, then I'd have let's say I lost. Let's say the district judge said, no, you have still an obligation to appeal. Same thing, file appeal to the Ninth Circuit. I'd say, here you go, these cases. So, and again, the issue is not, of course, I think I'm justified in the position, but it creates a risk. It just creates a risk for FINRA, the brokers, whatever. Because again, like I believe, I think the brokers know that without those arbitration provisions, their net income will be a lot lower.
And let's get into the weeds on that. Number one, it puts them in front of a judge. Number two, they now you're as the plaintiff filing a complaint against your broker dealer in federal court, you now have the access to all the federal rules of civil procedure and evidence, which in arbitration you do not. Case in point, what do you have to do to get the deposition? What's the standard you have to meet?
Yeah, extraordinary circumstances. Yeah,
extraordinary circumstances. That's not the standard in federal court. There is no standard. Once you get to discovery, if you want to depose somebody, you can depose them.
So if you're requesting evidence, it's whatever is discoverable or is reasonably likely to lead to discoverable evidence. You can take depositions, but the biggest difference, I think, besides you have automatic access to discovery, is you have the right to a jury trial. And whereas three guys who get paid through a FINRA system may be like great, smart, and fair, let's say fair, so that they may rule in your favor, unlikely that they're going to be so stimulated to issue a large damage award.
Right. Well,
just unlikely.
Right.
And obviously the brokers know that. And if
let's be honest, they go through FINRA's training. Come on.
Right. Well, even if I'm giving them the benefit of the doubt, just kind of how it goes. But if you're before a jury, you never know, and all you need is like one bad hit. I mean, really bad hit, and it could be a big number, and it create a precedent, and you're kind of screwed.
Yeah. And being in federal court for these broker dealers, it would terrify them because the shenanigans would be open to discovery. It would be open for the entire world to see. And they desperately don't want that. Yeah.
And now
let's use the real world example on why they don't want that. And think about what, well, you weren't on the call, but I know many of you were when Wes Christian was on the call the other day. Okay. And what did he say? Most of our cases settle out and they're confidential. And Mark even tweeted about it today. That Forbes guy was yammering about how Wes doesn't have any proof of all these blah, blah, blah. Well, of course he doesn't have proof. He's not permitted to talk about it because they all signed NDAs during the settlement.
Yeah.
There's a reason they do that. There's a reason.
Yeah. And I was going to say, so that's not uncommon in any dispute.
Sure.
Just to let you know. But there's more reason in these disputes because they don't want information to come out that others would use against them.
Exactly.
Yeah.
Exactly.
And, you know, and because of that, and we're using the arbitration again, because we're just taking it back and we're just kind of speculating that because there's issues about the authority of FINRA and the system, we're kind of speculating if that's going to come into attack and under attack. And we know it's been attacked. Listen, we attacked it in our actions that were filed here, but that was without these cases that were available.
Right.
And, you know, again, the court seems inclined, the court being the Supreme Court, the court seems inclined to want to limit. So maybe they'll require some more formality to arbitration provisions, or maybe they'll make some ruling, maybe not, by the way. They may just say whatever, and it's not. But again, like I said, the point is you create doubt and exposure and risk because they don't know how it's going to turn out.
That's right.
And you know, again, like the financial risk is substantially different in a arbitration, a FINRA, whatever arbitration versus whatever would happen in the federal court.
Right.
Okay.
Right.
Anything else you want to add?
No. I mean, it's just the last week has been extremely fascinating with all of this stuff. You know, you and I talked about this when we first started looking into GTII, when we read Alpine's complaint when they were in the Tampa court. Like, how can you not support this? As much as we don't like Alpine, we think they're we think they're criminals. Sorry, we think they're criminals. But how could you not support it? Because they're arguing everything that we've been saying for the last 7 months. Yeah. And, you know, now you're starting to see these appellate judges agree with them.
Yeah. And we when we looked at the J case that's going up to the Supreme Court, we kind of suspected that that's where Alpine's lawyers got their arguments for their whatever they're doing here.
Exactly. Yeah.
It seems like they're kind of trying to fit within that.
They're trying to fit. And we had talked, remember, you and I had both talked about it. We initially thought it was nothing more than the delay tactic. But now after we read that case, we're like, we think that they're formulating their arguments based on that appellate court decision.
Yeah, we were literally talking last night about if the decision was going to come down today and whether it was going to be a stay today. So we kind of felt something was going to happen. And again, you know, a lot of this stuff is kind of goes both ways, because if you're a GTII fan, that was 3 eyes, I think, you might be like disappointed because there's a delay. I don't know, by the way, if that delays the stock, you know, whatever stock action, who knows? Because I don't know if it does. Because that might run on a different track. But let's say the proceedings involving Alpine are slightly delayed. But on the flip side, if that gives us new remedies against FINRA and the SEC, then that's the good part. And, you know, in large part, because we've obviously been in the MMTLP crowd and wherever else, it's been tough. And we've tried all the various venues. But FINRA and the SEC are kind of like, there's not much we can do to impose any risk or get any remedies for them. And if that changes, that really would change kind of the concourse. And it'll be interesting also because, you know, we talk about this because FINRA is a private company, which is in this case is going to be, I think, and you think too, in this case, it's probably going to be bad for them. It might impose a lot more responsibility, which they could chase, you know, others for. But they always flout that, you know, they kind of flout that we're SRO and we're not government, we're not state actor, because they thought that insulated them. But it might in this case not. You know, in this case, it may work opposite. Again, we don't know. We're just, again.
I mean, the FINRA lawyers now have to be taking a serious look and saying, okay, how are we going to get beyond this? Because if they're, again, going back to what we talked about, if the Supreme Court finds that there was unconstitutional delegation, that they denied the jury trial right, it just flows. It flows. You've got two major aspects of what FINRA is supposed to be doing now deemed unconstitutional by the Supreme Court. How can the argument not be made to say, well, you basically took their authority away to act, you took their authority away to enforce. How can they continue to have immunity? It doesn't make sense.
Also, like, just think about this. You ever hear those, like, there'll be a bunch of convictions that are thrown out because there was like fraud in the investigations. The cops they find out that the cops made up the evidence of 500 cases. And I'm making something up, by the way. And there's 500 convictions, and they have to overturn those convictions. So what? And we haven't really talked about this part. So what happens if they say, anybody who's subject to an enforcement action is a right to a jury trial? And I'm a guy 2 years ago, I got knocked out of the water. Does everybody now have a right to come back and have a new hearing before a Article 3 judge?
Well, here's my argument to that. That would only make sense for the organizations that have been booted out. But for the organizations that have been fined, it was always pennies on the dollars. It's going to cost them more to relitigate the issue to save themselves the $1 million fine that they paid for naked shorting or fails to deliver or, inadequate blue sheet. I mean, the fines are pennies. They're nothing.
Except it's that element, that fine, that made the delegation improper.
Exactly. So then would FINRA have to pay those fines back?
Yeah, I don't know. I mean, like in the GTI case, if they were proceeding, I was thinking about that. So even under this order, and I have no idea, so more speculation. So if they wanted to proceed, how about if they just said, we're just going to go after the violation of cease and desist, no fine, no expulsion, no nothing. So aren't we good that way? That's one way if you went through the FINRA system, SEC system. And the alternative way, as I indicated, was just go through the federal district court and seek some interim remedy. So kind of what that means is if you file a case, you might have like some remedy at the very end of the case. You win a case, you get some money or whatever. But during the case, you may want something to happen, and you have the right to kind of take action to get something to happen. So in this case, perhaps if you can't get Alpine kicked out, maybe you want them to be supervised very carefully by having somebody run their business, have access, because this is the part I liked. I don't understand why FINRA didn't do this anyway.
Right.
But once you had like somebody in there operating as a receiver who had to report to a court, then you would have access to all the books and records too. And I would guess if Alpine is what I've heard they are, they would probably not want a outsider who had to report to a court to have full access to their books and records.
Right.
So that's why I was kind of surprised when FINRA, when the order, the cease and desist order was put out in April of 2022. That's why I was surprised they didn't act in that manner at any point. That's
a real open question. Why did they drag it out for so long? What I mean, they had them. They had the
I guess
booting them out.
Yeah, I guess the issue would be, so I don't know if this is the case. So there's apparently in excess of 35,000 violations, right? After the cease and desist order. I don't know the precise amount. Is it possible that they all occurred in June of 2023? All at one time? I guess is possible, but more likely was probably, a little bit here and a little bit here and a little bit there. So you would think if you had somebody who you had issued a cease and desist order and found that they were a risk to public health, that you'd have some casual monitoring of what they were doing thereafter. Didn't sound like they did. And I agree with you. That is either just absolute incompetence and unjustified incompetence, because people got ripped off after you said people got ripped off,
right?
Or it's something else.
Well, or it could have been hey, I'm going to pick up the phone. Hey, look, we got this enforcement action. Yeah, we're going to calm down. Yeah, we're not going to do X, Y, and Z. Don't worry about it. Can you just hold off on enforcing it pending the appeal? Don't worry about it. We'll be fine. And then they hang up the phone and they do all over what they've been doing.
And I agree with Ted. Let's release the blue sheets. Let's also release the green sheets too.
Yeah.
Whatever. We just want access to the information, obviously.
Right. Transparency.
And the other part of this, and just to kind of be clear, so this is all good. We all okay, not everybody, but in our sphere that we speak of, there's not a lot of fondness for Mr. Gensler or Mr. Cook.
Right.
And obviously we've all heard about that Gensler might be at risk. And we all want Mr. Cook to be at risk. But we don't know what's going to happen if those guys get replaced. And there's been, as far as I'm concerned to this point in time, and I'm just trying to I'm looking at the big picture, at least the way I see it. Whatever legislation's been proposed, I don't think is designed to assist retail.
Right.
To me, it would kind of limit the investigations that go on, and I don't think it'll require investigations into MMTLP or GTII or GNUS or whatever. So I'm concerned by the confusion or potential confusion that by getting rid of Gensler and Cook, that automatically solves the issue. I don't.
It doesn't.
I still think it has to be, and I don't think it has to be over-regulation. But listen, I was going to say a bad word started with an M. That's not politically correct. But any person who looked at the MMTLP thing for 15 minutes, they might have to take a 5-minute break somewhere in there because it's confusing. But basically, listen, these people paid for shares. They don't have them. That's what it is.
Right.
It's not any more complicated than that. And explain. Nobody is explained. That's just unjustifiable.
Right. Well, it goes back to what we've said all along. I think you solve the problem with there's one way to solve this problem with all this stuff, and that's transparency. We talked about, you and I have repeatedly talked about this. Release the blue sheets. That solves the problem. That answers all the questions. If MMTLP, and again, we're generally talking about MMTLP here because it's frozen in time. If there's nothing wrong, then there's no harm with releasing the data. If there's nothing wrong, the numbers should match 165.5, 165.5. No harm, no foul. But the fact that we're 7 months into this, we still don't know what the final share count is we're not, Congress isn't answering the question. Reporters aren't even asking the question. Judges aren't releasing the information per the decision in Mark's petition. So you have to take a step back and go, what's the problem here? This seems elementary if you think about it. It's a simple.
Yeah, I think an in-camera review by a judge is an easy solution because they can verify numbers. That's all.
Right.
No disclosure of confidential information.
Right.
To me, it seems like an easy one.
Right. And Finra's attorney could have suggested that as well, too. In fact, that was one of the things Mark asked for.
Right. And, I know today, by the way, Mullen announced the hiring of Wes.
Yep, I saw that.
To handle it. Unfortunately, they went through like a reverse stock split. I think between the time, and I don't know this for a fact, but between the time they kind of got started and then they went to share Intel, and I don't know what the contractual arrangements are, but they hired Wes. I suspect that Wes would have not recommended a reverse stock split. That's my guess.
Well, so did retail.
Yeah, I know. Retail was like saying a lot of words. Like I see FBD. There's some letters in there that suggest those kind of words.
Yes.
But ultimately, my point is the regulation is, too much regulation, not too much regulation. It's just got to be enforced. And there's got to be I've said this like 1,000 times. There's got to be a wall between the regulators and the capital market. There's got to be a wall. And in terms of somebody's asking about RICO, so there's civil RICO and there's criminal RICO. So if people want to go to jail, that's fine. I don't mind that. I don't have any particular, other than like JR, I don't have any particular candidates for that. But he's willing. He's willing. Civil RICO, obviously several of us have filed those claims. Maybe with the right set of facts, the right judge, the right court, maybe somebody will be successful in asserting that. It's not like the RICO claims have been accepted and been successful in the past. Just in so far in our matter, and again, we have a very confusing set of facts, because that's another thing you have to, and I don't want to be cynical, but we've lived this stuff for like a long time by now, 7 months. So all of us, or most of us, can address the facts by heart, and we kind of feel it. It's part of us. But if you're a judge and you look at something like once for a half hour, and then maybe 2 months later, the same, it's a pretty complicated scenario to have a real good feel for what, really the case was. I tried, by the way, in my part of what I filed like some ridiculous number of briefs, because I was trying to make sure the judge had as much repetition to kind of understand. We had we went through, I think we had 75 filings in my federal court, just a federal court case. And a lot of it was just educating the court. So I think unfortunately, this is a really complicated scenario. It's hard to get a judge interested, hard to get, obviously the people have gone to Congress and tried to make, you went, right? And I know like William Ferrand went, and Ham went, and Anna, and Syntax, and all those other people. If I omitted anybody, I include you right here. You're included right here. Much appreciated. That's a tough thing to do. Tough thing to get results, especially when you're explaining to somebody who may or may not be receptive.
Right.
If somebody's not receptive, and you could say, whatever, it doesn't make a difference. And then even if they are receptive, to kind of have a real understanding why this is not like some bullshit story, like every other bullshit story. And I have to be honest. So and I think I've said this before, a client comes into me, and I've heard a lot of clients say whatever the story is. And I know that the story they tell me is not the story. It's their version of the story.
Yeah.
And if it's the worst thing in the world that happened to them, to be honest, until I hear it out, I have some doubt that it's the worst thing that happened to them. So that's what happens when you explain it to people. Unfortunately, they minimize it because they think you're exaggerating, and they don't understand it. And it takes a while to get there. So that makes it tough for us. That makes it.
Yeah. The facts are very convoluted. They're very confusing. And we know this because we've personally tried to explain it. We've heard other people personally try to explain it on calls with reporters. I think in my mind, that's why I simplified it, and you know this, we talked about this. We both, were digging and digging and digging and digging to find out who got this thing trading, who signed off on the Form 211, where's it at? And at some point you just realize that in our minds, okay, yeah, that's out there, but is it super relevant to the issue at hand? Because the real issue in all of this is what we've talked and what we've been talking about is what's that final share count? It's that simple. What's the final share count? We were either sold counterfeit shares or we weren't. The numbers either match up or they don't. And the fact that, again, we're 7 months out from this and we still don't know that answer.
And I believe that JR and I neither of I are class action lawyers, unfortunately.
Yes.
No. There was a comment. Yeah, I agree. And it applies to every company that's been naked shorted, which is probably going to be like almost every company. Honestly, we know the ones that are targeted more specifically, obviously because we've experienced that, but it applies to everybody. And, today I heard, because I know there was some uncertainty. Today I heard Ham, and he was pretty specific that the person who may flip was from GTII, which I thought was interesting. And again, you
Yeah.
know, we don't know where that's going to lead. So
Right.
we'll have to see. So I'm going to quickly. Anything else you want to
I was
reference?
just going to say that the MMTLP situation is unique, and we were talking about this on a space call earlier. It's unique in that it's frozen. Nothing is ever going to change with it right now. You know, whereas all these other tickers, GTII, Finger, pick one out of the sky. They're all trading, so it's easier to hide the fraud. It's easier to hide the naked shorting. It's easy to hire the fails to deliver. They can't do that with MMTLP, and that's why it still blows my mind that no one in authority, no one in the media is asking that one relevant question. That's all.
It's so disturbing when you see those articles come out and they appear that the writers may have been purchased.
Yeah, there's no doubt. There's no. And look, I'm not a conspiracy theorist. I'm not one that was, walking around last year this time saying the media is lying to us. But how can you not think that after going through this situation? How can you not read these articles and the one relevant question to all of this isn't even asked? It isn't even addressed. They sling mud at West, they sling mud at the community, and they fail to ask the one simple question.
Well, you remember like that specific Forbes article, I think that was the one that attacked Wes, and he basically claimed there was no such thing as naked shorting, even though prior to the time he wrote the article, the SEC had started an investigation or an indictment against somebody for naked shorting. And this is before he wrote the article. There was that Texas bankruptcy court, the Scilex Sorrento Therapeutics, where the judge specifically found naked shorting. Now, so either like somebody's intentionally trying to not provide the full story, or they're incompetent. Either way, it's not a good, it's not good. Like my view of FINRA and all these regulators are, we either got incompetence, corruption, or a combination. I happen to think it's a combination, which is the worst combination.
I think it's 80-20. 80-20 corruption, 20% incompetence.
Yeah. Okay.
They're like, oh shit, well, look at this. We oversold. Push it away.
All right. Anything else you want to do? And I'm gonna sum up a little bit.
No, I think we're good.
Okay. So kind of what we talked about was the decision in GTII, which not GTII specifically, but it's Alpine versus FINRA, and FINRA's ability to do an expedited disciplinary action has been enjoined. And there's a whole briefing schedule that ends in October. And at some point in time, there may be an oral argument on the appeal. And we talked about that. We don't think that changes the substance of Alpine's position. And we directed and suggested that maybe FINRA should try federal court to go get relief against Alpine related to the cease and desist and to protect the public. And then we talked about the Jareasky, whatever, decision and the order on the appellate order today. And we talked about how it kind of like focused on improper delegation of constitutional authority to SEC and FINRA, how that might kind of cut the legs out of those agencies, how it might impact their claims of immunity to exposure to civil action. And we also said it might have an impact on arbitration or mandatory arbitration. Anything else that you can think of?
No, just one comment on Jareasky, however you pronounce it. Okay. Was that in front of the full appellate order, or was that the 3-judge panel? Or was it the full court? It doesn't say en banc.
Yeah, I don't know. I'd be guessing. I think I think it was 3. I think it was 3.
It was 3. Yeah.
Yeah, so it wasn't the kit and caboodle.
It looks like it was 4. Davis, Elrod, Oldham, and Jennifer Walker Elrod.
Those are my favorite. As it turns out, those are my favorite judges.
In the Fifth Circuit. You're not even in the Fifth Circuit.
No, I'm not. I'm not. I'm
Pull
barely
them
in the
up.
ninth.
I'm not how to
I'm
pronounce that
barely.
name.
I'm barely in the Ninth Circuit, to be quite honest.
You're barely in the Ninth Circuit.
Yeah. Anyway, so I think we think that this stuff might impact retail's, let's say, communication with and association with FINRA and the SEC. Hopefully, it will lead to better regulation for the benefit of retail, but we don't
Right.
know. And we don't know how it's going to impact FINRA and the SEC, but we think it
Right.
will.
Yeah,
Anything else?
I agree. I definitely agree. It's going to have an impact, but that impact is yet to be seen.
Yeah, and again, for those at GTII, it does not change anything substantively. Only it appears it might delay Alpine's cessation of business, depending
Austin,
on.
go ahead. Sorry, I'm sorry.
Yeah, that's okay. Depending on what action FINRA takes and if they go federal court or not.
There's a question. Does this impact Wes's case against the other market makers, including Alpine? This doesn't impact Wes's case at all, even against Alpine. These are constitutional questions. Wes's case is based on statutory provisions being violated, whether that's spoofing, naked shorting. I don't exactly know what the complaint Wes has filed, but the answer is no. This does not impact Wes's claims. We can definitively say that.
Yeah, this would be a private action, and what we're talking about is more like quasi-governmental action, which would be treated differently.
Right. You're talking about, at the end of the day, we're talking about the authority of the executive branch to delegate power downward. That's what we're talking about.
But it might, we don't know, because we don't know what his theories are, but it may provide him some fodder in here to add to his case. So we don't know. I don't think it would hurt him, but I think it might help.
I don't think it would hurt him, but I think I'll bet you top dollar he's reading them, or some law clerk is reading them to see if there's useful information.
I agree. Okay. What was going to happen to GTII after Alpine thing is sorted? Can you tell me, JR?
I think it's anyone's guess. The short answer is I don't think anyone knows.
Yeah, not financial advice. I think the people that thought that GTI would do well thought that if Alpine was forced out of business, that would start a sequence of events that would cause the stock price to rise. So they think that if FINRA could act quickly against Alpine, that would be good for the stock. I don't know, but that's kind of, I think, the general thought.
That's the general consensus among the GTI community. But I think at the end of the day, no one knows, and me included. I don't know, and I'm a GTI holder, but I don't know the answer to that question.
Yeah, I have GTII too, by the way. Yeah, you just and I think Ham would say you never know when a stock's gonna go. You never know. And you never know what's going to cause it. And like I said, when and I'm not saying this is going to happen again, but when some event happens and the stock goes kind of crazy, it's not like I can call it at 428, the stock's going to go crazy. It's more like 435, 7 minutes too late, I realized the stock went crazy. That's kind of more the natural sequence of events.
Right.
But I think the more completion there is against Alpine, and the more they're limited in terms of what they can do, that's perceived to be better for the long stockholders, not legal advice, not financial advice.
Well, the other thing I was thinking about with the Alpine case is forget about the substance of the litigation, the length this could take to work its way through the court system. They could end up falling flat in their face before this even gets to the end of the litigation. I mean, we talked about that FINRA expulsion is their death sentence, but I think Avid was on a space call or did a video talking about they're running out of clients and they're running out of money. Yeah. So at some point, they're either going to need additional funding, more clients, they're going to need something, because as you and I both know, the Supreme Court isn't going to review Jareasky we might not see a decision in the Supreme Court case until next June 2024. And if this litigation holds off, or this litigation continues, this trial continues, that's dollars out the door that they've got to spend on this particular case. And Finra can still make life miserable for them.
Yeah, and you're right. And legal fees are expensive for GTII, and they can, again, we don't know what their end strategy is. Alpine's end strategy. Are they just kind of like holding on, and they hope that gives them time to coordinate some efforts, or do they expect to prevail? I'd be very surprised if they expect to prevail. I think, and again, I don't know, but I would think it's more asset protection work, kind of that
Right.
kind of stuff, to insulate themselves, give them enough time. And so there's some, just so you know, there's some, and I don't know where they are, what state, under what rules, but let's say you're in California, and let's say, you're expecting a judgment and you transfer some property. It depends on how long before that judgment comes in that you might have an ability to kind of reverse a transaction.
Right.
So maybe you can hide it. For example, and I'm not saying, was it the Kramers in GTII?
Yeah.
That's the guys? Yeah. I'm not saying they're doing anything, but let's assume for the sake of our discussion, they wanted to hide assets. And they started, today, and they thought they might have 2 years before they would have, somebody would say you hid assets. That might be long enough for a statute to have run.
Right.
And so there may be I'm not saying it's a good reason. I'm not saying it's justified, but there may be a legal strategy in just delaying with regard to moving assets, taking them offshore, putting them in different names, letting time pass.
Right.
I've been affiliated, knew some attorneys that did asset protection, and those can be very extensive and very costly to pierce. Yeah. That's where they're done. So it's very possible that those guys may have been involved in that. We don't know. We're kind of like everything else we do, more guessing.
Yep.
Yeah.
Yep.
Okay. Anything else you want to talk about?
I guess Danielle Spears, that's Bailey. Yes, Bailey, you could hire Mark Bazil to file a RICO claim on your behalf.
Yeah.
I would suggest talking to him, though, more specifically about it.
And also, I was going to say the other thing is, like, I pursued Fidelity. I did not pursue the market makers. So somebody might decide in the future, right, if they think they have a claim, maybe. And who are those alleged market makers?
Bailey, I'm sorry. I apologize, Danielle. I quickly glanced at that picture and I thought it was someone else. I apologize.
Who are those purported market makers that may have let MMTLP trade? Was one of them like Canaccord? Was that one of them?
Canaccord
and GTS? Was that those two?
I believe that's what the speculation is, yes.
Okay. We don't know for certain, even though there's that investigation involving Canaccord and some kind of market making activity. So we don't know if that involves MMTLP, but that's kind of the rumor. So maybe when that's more certain, I'm sure people will go after them. Whether they exist or not, I don't know.
Right.
But because somebody could go BK. We talked about this. Somebody could file a bankruptcy. They could liquidate. They could reorganize. But ultimately, if there's ongoing business and they don't stay in charge, again, their books and records are at risk.
That's right.
So if they're crooked, do they really want to expose their books and records to a federal bankruptcy judge?
Exactly.
And potentially commit bankruptcy fraud? I don't know. I doubt it. But who knows? Oh, I don't know.
George already has the blue sheets. I could subpoena the data from George, right? If I said it would help frame my case.
Yeah, my guess is I don't know, but my guess is nobody has the blue sheets.
Yeah. Plus, remember the title of the show is not legal advice. So, yeah. Danielle, if you're that interested, I would suggest speaking with Mark. Us two, we're not real lawyers. Actually, Richard's a real lawyer. I'm sorry, Richard's a real lawyer.
But I agree, JR's not a real lawyer. We're in agreement there.
Thanks.
Yeah, for me, I'm trying to I'm going to do backwards. So I'm going to request the blue sheets from Fidelity as to Fidelity.
Mm-hmm.
So we'll see. And I know they're going to oppose it, and we're going to get into a battle. But that's kind of the way I see it. And
Well,
I don't know, I don't even know what the blue sheets, what information is, or who knows.
I have them right here, Richard. Don't worry.
You do.
Afterwards,
Okay.
yeah, I've got them.
We all just want green sheets. We want big green sheets of money.
I'm joking, people. I do not have the blue sheets. Total joke.
I think he does. Maybe we could subpoena JR.
Have at it.
All right. I suggest Danielle hire Mark to subpoena the blue sheets from JR.
I'll call Mark now. I'll turn them over. I'm tired of this. I need to be more transparent.
Yeah. Okay. Yeah. So anything else you want to add?
No. Good conversation, Richard. This is, this is good stuff. So,
yeah. And again, we're just kind of throwing it out. We have no knowledge. We're just discussing possible issues. And we figure that others are probably discussing those kind of issues too.
Right. And these are the conversations that we've been having privately that we're now having publicly. And it's easier to do it in this format than it is on a space call, just because you get a tremendous amount of questions and you ultimately get off topic. So this is how we decided to do this. And it's good stuff. We have good conversation. We're educating people and, putting our thoughts out there.
And we were able to see the comment section. So if anybody in the future has specific questions or that, feel free, whatever you want to ask, we'll make up an answer, even if we don't know it.
And I want to point out that the last 2 lives that we did, Richard has not frozen at all. So I think we got the tech down pat.
Yeah. I think for us, we've got the tech down.
Yep.
That's the next step. Anyway, we hope this was not super confusing. I know it is confusing. I know it's confusing. We were trying to hopefully kind of make it less confusing.
Danielle, you are not earning points with me right now by that comment.
Yeah, I agree with you, by the way, Danielle. Hopefully it's less confusing after we're done, but if we made it more confusing, just blame JR.
Yeah, just blame me. Hit me up. It's my fault.
Anyway, what we're going to, as we said in the future, kind of as things pop out, if we see like a case or a ruling come up that we think impacts everybody and they might be interested, we'll just pop on and kind of do that. So I don't know anything about Share Intel because I don't have a contractual relationship other than I saw Mullen had a relationship with Share Intel also before they hired Wes. At least that's my understanding. And I'm not a big fan, just so we all know. Not financial advice, not a big fan of the CEO of Mullen. Not a big fan, just to be clear. All right. Anyway, everybody have a great night. Be well. Take care.
You too, man.
Take care, JR. Talk to you soon.
All right, we will catch up.
Okay. Take care.
Yep. Bye.